Okay, welcome everyone to the February 2019 HR Best Practices webinar series. My name's Kevin Mosher. I'm going to be your presenter today. This is the first month. This is our first trial on the new webinar layout. So hopefully people can hear me and hopefully this works. And apologies in advance for any sort of technical difficulties that we might have. So we're getting used to this after many, many years of using a different platform. So I'm, confident, hopeful that this works out well. And so I think there's, opportunity for questions. There should be like a little question box. We're definitely, like in other months, this is just a one way. So we're not going to take, verbal audio questions from attendees, but we're going to just have the same type of chat box, and we'll see how it goes. So we're very, very excited over here on our end. So this month we are so again, apologies in advance if there are any technical difficulties due to user error, basically me not knowing the system very well. This month, we are going to talk about workplace accommodations for dummies. And, not that anybody on this call is a dummy or anything like that, but I think you get the point. We are going to do a top-down review. We are going to primarily focus on the ADA. That is the most confusing. It's the most difficult part of accommodations, but we will touch on FMLA, we'll touch on pregnancy, and we'll touch on the Fair Labor Standards Act as well, because I'm sure you all know that the Fair Labor Standards Act requires accommodations in the workplace, right? So we will focus on those things, but really the ADA is our go-to, and then we have some examples later on. And I absolutely love this. The next 3 months are three of my favorite topics. My overall favorite topic is probably talking about figuring out overtime calculations under federal law, which I just think is really, really cool with the different mathematical equations that can be involved. But this month, we're going to talk about workplace accommodations for dummies. And then next month, we are going to have a basic primer on family medical leave. And then we're going to have, an advanced webinar on FMLA. So February, March, and April are going to be really, really nice, substantive, your meat and potatoes of HR topics that pretty much every HR person deals with at some level or another. For those of you that don't know me, my name's Kevin. This is a newer picture of me. I'm smiley, happy in it, and I'm a certified specialist in labor and employment law by the MSBA. This is my practice. I'm an HR attorney. And I manage the Minnesota office for Thompson Co., which is a national defense firm, if you are not familiar with Thompson Co. We have unique at Thompson Co. If you've seen anything like this else in the country, I've never heard of anything like it, but we have a really phenomenal monthly subscription-based model HR counseling program. So literally call as much as you want with any sort of HR questions, no legal fees. You just pay $79 a month. We have premium packages with extra legal stuff, including handbooks and the like. Month-to-month program. Any of you, if you're not on the program already, you're welcome to call or contact us about membership. It's a really, really cool program, and a lot of companies around the country use it, and I assume because they stay on it, find it very valuable, especially for $79 to be able to call a lawyer, is a pretty amazing deal that you're not going to find elsewhere. Okay, so services that we have at Thompson Co. We do, and as part of the myHRgenius program, includes the hotline, webinars, updates. Thompson Co. provides all these things. So definitely want to make a plug for Thompson Co. and all the stuff that we do nationally, in defending companies and insurance companies and businesses throughout the United States. Okay. So we're going to move on to the topic. So we are going to focus, this is accommodations for dummies. We will touch on, I will definitely touch on some nuanced topics that are going to be important for advanced, HR professionals that, know the basics of this. But I think it's always nice to just kind of overview the fundamentals of, where did we come from? Why do we have to talk about accommodations? Why is this important for businesses? So we'll talk about the laws. We'll definitely talk about some advanced situations and concepts. We'll talk about disabilities, what they are, what they aren't. We will talk about FMLA as well. Like I say, we'll talk about pregnancy leave in addition. And then we'll talk, the most important thing that we're going to talk about is really getting to an understanding of what the interactive process is. It is one thing to understand the elements of a disability, of like an accommodation situation. And so often I talk to businesses and HR professionals and maybe not the HR professionals as much as the managers. And the managers tend to say this sort of thing to me and to the HR people that I work with. This person's not disabled. Okay, well, that's great. I mean, most of the time, most managers are not doctors. And so do you really want to put all your eggs in the basket of this person's not disabled? They watered down the law about 10 years ago to make about half the country technically disabled under this law. So it's better to have a strategy. And the strategy almost always includes an interactive process where we discuss with the employee. Sometimes we get the employee's medical provider involved, but we want to talk about their limitations, physical, mental limitations, the impact in the workplace, and then what we can do to try to accommodate those. So that's kind of very, very briefly the interactive process. We're going to dive a little deeper into that, but I want you to really understand that accommodations are a strategy. This is just not one of those things. This is not one of those topics where you're just like, oh yeah, the person's not disabled. It's not like, oh, they didn't work for you for 2 months. Like that's an objective thing that's really easy to figure out. Disabilities, limitations, there's so much subjectivity into it that we really need to have a strategy. And then when you start mixing in FMLA and work comp and all these other laws, it gets complicated. So we need to have a strategy in this webinar. Hopefully will help you with that. Okay, so let's start with the real big topic that we're going to focus on today, and that's the ADA. So if you're unfamiliar, the ADA was amended recently, so it's technically the ADA Act as amended, and it is the federal law that basically says that protects employees and applicants, so I want to point that out, and applicants as well, from disparate treatment, discrimination in the workplace. So like sex discrimination or gender discrimination and all the Title VII forms of protected status. So you've got, in the ADEA has age discrimination. So you've got like gender and age and religion and, in some states you've got sexual orientation, but and other things. So we've got about 13, 14 protected statuses. Disability is one of them, as protected by the ADA. So with disability, we definitely don't want to discriminate. We don't want to, discipline somebody or fire somebody or not hire them if they're an applicant because of their status as being disabled, because of their disability, whether it's real or perceived. The ADA also covers perceived disabilities. So we definitely don't want to assume somebody's condition makes them disabled. So you need to not, discriminate, disparate treatment, treat them differently than other people who aren't in that same protected status, so who are not disabled. Federal law prohibits that. Now, what the federal law and a lot of state laws too also require that isn't as well understood is that there is also a separate legal argument that's called failure to accommodate. And failure to accommodate literally is that if you fail to reasonably accommodate the known disability of an employee, then you've actually violated the ADA. So that's not just like you're treating them differently. That is that literally you are required under federal law to engage in this process where you actually need to reasonably accommodate the known disabilities of an employee, and that's failure to accommodate. It's a separate standalone claim that can be brought in court. So we need to understand that we're not just trying to accommodate employees in the workplace because they're disabled, just because that's like the right thing to do, and because we want to make sure that we're treating them well. We actually are required under federal law to provide reasonable accommodations to these employees. And then the third prong of the ADA protections is that you can't retaliate against employees because they complain about their treatment or because they've complained that they haven't been accommodated in the workplace reasonably. So, no retaliation, right? I don't think that's going to really surprise anybody. A couple things on ADA that you can see from the slide: covers full-time and part-time employees, unlike the FMLA and some other laws that have a minimum number of hours or minimum number of time worked for the company before they're eligible under those laws. The ADA, no, it protects applicants. And it protects current employees. And I don't care if you're working 5 hours or 55 hours a week, or if you're a brand new employee, or if you've been working there for 20 years, the ADA protects everybody. And it protects applicants too, to the point that you need to make sure that if you're doing interviews or if you're opening up the job, that it's accessible to people, that the interview or the job application process is accessible to people with disabilities. And that's different than making your physical building accessible. For with ramps and things like that. That's not what this is. This is literally as part of the hiring process. If for whatever reason you invite somebody in to come in for an in-person interview and they need some sort of accommodation, whether it's in a room on the main floor, or I don't know, I'm just guessing what somebody might need, maybe for you to speak slower or something if they're deaf and they're reading lips or something like that, or they don't have a sign language interpreter. You are required as an employer to reasonably provide accommodations for those applicants as part of the process. Now, they have to be a qualified individual with a disability, and we'll get into what that means, because that's kind of where the employers get the opportunity to really push back a little bit on the requests that employees or applicants might make. Okay, so we're not going to dwell on this too much, but there is the FMLA, Family Medical Leave Act, and the FMLA. If you just boil it down, this isn't an FMLA presentation, but if you just boil down the FMLA, it only applies to employers with 50 or more employees. So if you're a smaller employer, you don't have 50 or more employees, then you're not even going to be covered by the FMLA. Still come to the webinar next month, and you'll learn all about the FMLA, because hopefully you'll be bigger someday through growth. But the FMLA is a time off statute. So it is a time off entitlement. So a lot of times companies get really confused about the FMLA, and they think like, do I have to accommodate the person? And how does this work? How do I count the time? How do I not, when is the person eligible? It's a time off statute. If the person is taking time off, then it counts toward the 12 weeks that they get per year for the FMLA. If the person is, if they need an accommodation, but if they come in for say they come in for work, say they get injured in the workplace. So this is where work comp gets involved, and they come in and they're working light duty. You've made a light duty because you don't want the insurance company to pay wage benefits, because that goes against your ratings, and you want the person to hopefully get miraculously better and stop just doing nothing, and because they just all want to stay home and eat Cheetos and get paid for it because of their workplace injury. And so what you want to do is you're going to offer light duty, right? So you don't get to count that as FMLA. FMLA is a time off statute. You only get to count FMLA when the person takes time off. Now, what the one thing that the FMLA does allow is that if you are in a situation of intermittent leave, and if you're unfamiliar, intermittent leave is where the person has some sort of serious health condition or chronic condition, whatever it is. Let's just call it epilepsy, and the person needs, you know what, better, the more common example, not epilepsy, is migraine headaches, right? So the person has a need for intermittent leave because they just don't know when the migraine headaches are going to come on. So the migraine headaches, there's no rhyme or reason to them, although in experience, migraine headaches tend to occur on Fridays. But, that's, just what I've noticed over the years, that employees like to take Friday off. Okay, so migraine headaches, and they don't know when they're going to be able to take off. So that's intermittent leave. It's coming and going. They might take off a day 1 week, and then they might not take off any time in a month. That's intermittent leave. Under the FMLA, there's no accommodation requirement under the FMLA, except for intermittent leave. You do have the ability to move somebody to a position that better accommodates the intermittent nature of their condition. So if, for example, you have a position, so say our migraine headache person is in a position that you just can't have that person just coming and going, erratically. Like it doesn't work that way. You can't do that. It doesn't make them qualified. Well, rather than letting them go home and just sit around at home for 12 weeks, they're really not qualified for the job. You could put them in a position, they have to get paid the same, but you could put them in a different position that they're qualified for that better accommodates the intermittent nature of their condition. So the migraine headaches in this situation, and that's really the only accommodation situation for FMLA. Otherwise, FMLA is a time off statute. Now, ADA, we'll talk about different types of accommodations, and time off is one of the ADA accommodations. And if you give somebody time off under the ADA, you should count it toward their 12 weeks of FMLA. But FMLA in and of itself is a time off statute, except for this one situation where you've got the accommodation for intermittent leave. The Pregnancy Discrimination Act, another federal law, requires non-discriminatory treatment of pregnant women in the workplace, right? So it's best that we don't discriminate against pregnant women. It doesn't protect men who are not pregnant, but who might have a pregnant spouse, right? So it's not going to protect them. But pregnancy, by definition, pregnancy in and of itself is not a disability. A lot of times, employees tend to talk about it like that, but it's really not. Now, an underlying condition, we'll talk about a definition of disability in a minute here, and you'll see why. Because pregnancy, there's a temporal it's temporally short, right? So it lasts 9 or so months, and then goes away. Disabilities, by definition, need to be longer term in nature. So just by definition, pregnancy is just a short-term condition, we'll call it, I guess, that goes away at some point, unlike a disability, which is supposed to be longer in duration. So with pregnancy, so you can't, there's no accommodation provision under the Pregnancy Discrimination Act, and there is no right for men. But what there is if you as an employer, and so this is what you want to be aware of, if as an employer you have accommodated other employees who are not pregnant with time off or whatever, however you've accommodated them, maybe given them phenomenal new desks or chairs or something like that, and you've accommodated their needs, and they're not pregnant, so you've accommodated them not because they're disabled, but they've asked you and for some time off to go, let's just say to go hunting or to go on some really, really long vacation or something like that they don't have paid time off for, and there's no normal unpaid leave of absence, and you've accommodated them and you've granted that to them. Well, you would be hard pressed to then not give that same sort of right two women who are pregnant, right? That could be potentially a form of disparate treatment. You're treating them differently. So why did you give time off to the, let's just call it, guy to go hunting for a couple weeks, and then a few months later you said no when the female wanted time off due to some sort of whatever, just extra bonding leave or something like that, after having a baby. Now, there could be an underlying condition, certainly, is right. So that would be disparate treatment. It wouldn't work, right? That would be the female, the mother there could argue that you're treating her differently under the circumstances because of her pregnancy. So there is, but we could get into an FMLA situation with pregnant women. Certainly any time that they take off is going to be covered by FMLA. Again, that's an unpaid time off statute. But also, we just want to be mindful that pregnant women could be disabled if they have an underlying condition that's created by the pregnancy. So if they've, if they need to be put, bed rest, or if they have some sort of other condition that rises to the level of a disability, then in that situation, we would then need to accommodate, and we would want to look at the ADA for that. Briefly, the Affordable Care Act, and I'd mentioned before the Fair Labor Standards Act, the federal law regarding like time, work and hours and pay, overtime pay and that sort of thing. Well, the Affordable Care Act amended, it's actually the Patient Protection Leave Act, amended the Fair Labor Standards Act years ago, back in the Obama administration, amended the Fair Labor Standards Act to say that employers needed to provide accommodate, let's just call it an accommodation since it's an accommodation webinar, a reasonable break time for mothers to express milk. Now, a lot of states have also stepped in or had already stepped in before that and already had laws on the books, or have had since laws on the books requiring employers to, do various things for employees so that they can express milk. But federal law, just focusing on federal law here, babies up to 1 year old, you need to provide the mothers who are expressing milk, who are feeding, you need to provide them private space that's not a bathroom, not a restroom, and they have to get private space that's free from intrusion from other employees at the workplace. And they need to be provided a reasonable amount of time. And a reasonable amount of time is typically 15 minutes, but it could go as long as 30 minutes, depending on the mother and, probably how the day is going. And so it could be 15 to 30 minutes unpaid. So as long as they're not working, as long as they're free from any of the distractions of work, and they're not expected to be on emails, and they're not answering phones, it's unpaid. And so you don't have to pay it. But if they are working, if they're just checking emails, if they're doing, then it's paid. Then it's going to be a paid thing. And it could run concurrent with breaks. If you have like a typical 15, 20-minute break or a lunch break, you could definitely, paid or unpaid. If those breaks, you could ask them that, hey, you've got a 15-minute break. Could you use your 15-minute break for expressing milk? And in that situation, then you would pay them for it if it's a paid break time. But just so you know, federal law does require of all employers, as long as you're doing at least $500,000 in a year in interstate revenue, it's going to require that you provide an accommodation to mothers who are breastfeeding and so that they can express milk. If you're a smaller employer not covered by the ACA, you can argue undue hardship, but that argument's pretty limited and non-existent for larger group employers who are covered by the ACA. Okay, now we're going to get into the ADA. Here we go. So we're going to talk about some key ADA provisions. We're going to get into disability. We're going to talk about all the elements of an ADA case. So ADA key provisions, and again, requires reasonable accommodation. So we've got the whole disparate treatment, like don't discriminate. You don't want to, be mean to people because of their disability. But the big thing here, so disparate treatment, we don't want that. But disparate treatment in addition to that, we definitely have the reasonable accommodation. So the requirement that you reasonably accommodate employees and applicants who are qualified individuals with a disability, so that you can accommodate them so that they can perform the essential functions of the job. And if you do that, if you accommodate people reasonably so that they can perform the essential functions of the job, then you are meeting your burden. And so what we need to do is we need to understand what is an essential function of the job. That's going to be driven by your job description. And every time I talk about this, I know for those of you that have been listening to me talk, about these laws for years, and we talk about job descriptions, you'll hear me say, like, what is one of the most important things that you can do, especially at the outset when you're hiring somebody? And the answer is, have a really good, solid, well understood, appropriate job description. The worst thing, and one of the primary reason that we do that, beside the fact that employees like to know what they're getting into when they apply for a job, best not to surprise them like after they've accepted, because that would be terrible. The thing that you want to do is have a good job description that describes the essential duties that the person is going to perform. Now, you might have the qualifications and all that. That's great. It's great to have the qualifications. It's good to have like an overview of the company, just generally. But the most important thing on a job description is what essentially are you going to do in this job? And we want to have this in writing. We want to have it provided to the employee. And we want to put in their personnel file, because if we ever get asked about accommodating somebody, or if we're, lawsuits, heaven forbid, if there's going to be a lawsuit, then we want to be able to go back and say, look, here's your job. Your job, you've got a lifting requirement. You've got to lift these boxes up and down all day long. That's going to be at least like half your job. And then, you also have to drive. And you need to be able to walk from location to location. And so you put these duties in there. Then if and when the person says, hey, I've got diabetes, and I'm going to have my, foot amputated because it's, getting bad or whatever, then you can look at the job description and you can say, well, I mean, the job requires that you drive. Are you going to have a valid driver's license after this? And if the answer is yes, I can still drive. Okay. We don't need to accommodate that. Well, how about the walking from facility to, warehouse to warehouse? How are you planning, how can we work with you to do that? Oh, okay. Well, we get it like a Segway scooter and you can go around. Okay. That's maybe something we can, maybe for our business, we are a larger business. We could accommodate you that way. Okay, maybe we can talk about that. But then lifting up and down, and well, if the employer then says, well, I just can't do that. I'm going to be on a lifting restriction of like 0 or 10 pounds. Like my prosthetic won't be able to take more than like 10 pounds. Let's just say, since we're all pretending here anyway. And you have a 50-pound lifting restriction because the nature of the job is that these are really big boxes and crates that are being lifted up and down. Well, then you have something to go back and you can say, look, how are we possibly going to accommodate this? But it's driven by the job description, which you have to understand at the front end. And so it's really important for HR people to work with the managers, the direct hiring managers, to make sure every time a job comes open, hey, is this still a valid job description? Does this appropriately, jobs change all the time, right? Does this appropriately reflect what the actual job is? And if yes, then great, then go out and recruit for that job. But if no, it needs to be changed. And so these job descriptions, we need to change them. We need to make them effective, because whether it's an applicant or a current employee, if they come to you and they've got a disability or some sort of new limitation or whatever it is, you need to, you don't want to just make up this stuff like, oh, well, essential to your job is lifting 50 pounds. And the employee's like, I've never lifted 50 pounds I've been working here for 5 years. I've never lifted 50 pounds. Well, okay. That tells you that the job description's inaccurate. You want to make sure that you have a good understanding as an HR professional, and that the managers aren't just making up stuff, and that they're part of the process and making sure that the job descriptions are are accurate. So questions we're going to ask about job descriptions. We have to understand what is reasonable and unreasonable. And I'll tell you right now, I don't know. What's reasonable for one business is not going to be reasonable for another business. So in my example with the Segway scooter guy with the amputee, I'm glad I make these things up on the fly and then try to build off of these stories. So with that situation, let's just say it's a larger employer and a Segway scooter. I don't know how much they cost, but let's just say it's $5,000. So in that situation, with a larger employer, say they have like 300-400 employees, $5,000 probably reasonable. Let's just say they make enough money. It might be reasonable for them to pay the money to get a Segway scooter so the person can go from warehouse to warehouse. But if it's a smaller employer, say the employer's got 25 employees and they don't have as much money and times are tough, $5,000 that might be unreasonable for them. So $5,000 if you're Amazon, no big deal, drop in the bucket. But $5,000 to a smaller business that might be completely unreasonable for them. So you need to understand your business. You need to understand the job. You can't figure out what's reasonable and unreasonable unless you understand the job and unless you understand the business. But so every time we look at this sort of thing, we need to this is going to be qualitative analysis, and we have to have a strategy here and understand the business and the job. Who are the qualified employees and applicants? We'll get into that with disabilities. And then what is an undue hardship? And undue hardship is very, very difficult. You really don't want at the counseling level with employees in businesses, you really don't want to get into what is and isn't an undue hardship. Those are legal arguments that get made at court, and hopefully those things are the sorts of things that can be avoided by having a good process at the front end of working to understand the disability and how it impacts the workplace. Clearly, though, there could be an undue hardship element that we always want to be considerate of, but that's not how we don't want to lead with that when we're trying to figure out an employee situation. Those are legal arguments to make and hopefully avoid. Okay, so what is a reasonable accommodation? So what do we do? So we start with a qualified individual. We've got an employee or we've got an applicant, and at this point, we are just going to assume that they have some sort of mental or physical limitation that prohibits them from doing something in the workplace. Now, it's that something in the workplace, that prohibition on doing something in the workplace, like one of their jobs, that we want to focus on. If somebody has a disability, let's just say you've got a skin cancer. Say you've got some skin cancer. And in no way does that skin cancer impact the person's performance of the job. Not to be rude, but who cares? From an HR perspective, do you need some sort of accommodation? It doesn't impact the person's performance. If it's just, little skin cancer is going to come and go and whatever, like if it's a big deal, obviously, and it impacts their performance, that's a whole different matter. But if it's just like some minor skin cancer and eventually it's going to, get surgeried off or something, and if it doesn't have an impact on the person's ability to perform, then there's nothing to accommodate. Like, okay, thanks for letting me know. Sorry about your skin cancer. If you need if it's impacting your ability to do the job in any way, please let me know so that we can figure out if you need an accommodation. So we need to understand, like, okay, yeah, the person comes to you and they've got some sort of disability, but we have to understand, like, how is that impacting the workplace? If it doesn't impact the workplace, if it doesn't impact their performance, if they don't need anything as a result, then not to be rude, who cares? We can, move on to other HR matters and that are a bit more pressing. Obviously, be as empathetic as humanly possible, but right, we just send them on their way. We don't have to tie up a lot of resources thinking about it. If for whatever reason they need something because it's impacting their performance, it's impacting the way that, their ability to do their jobs, then we'll get into a conversation with it and we'll explore these reasonable accommodations. When does this trigger for you? When the person lets you know. Now, they don't have to come out and say, I have skin cancer. I have migraine headaches. I have diabetes. What they could say is, hey, I've got this condition and I'm just going to need some time off. At that point, you can pry. Okay, what's the condition? I'd like to see some medicals on it. Oh, it's migraine headaches? Okay, I need to understand how that is going to impact you in the workplace. Oh, you need some time off because of the migraine headaches, and it's probably not going to always be on Friday, but it will be always on Friday. Okay, then I'm going to need to have some medical documentation from your doctor so that I can understand the world that we're talking about. So I want a framework understanding of what your medical condition is and how, and I don't care about the diagnosis exactly, but what I really want to understand from the doctor is what are the effects of the diagnosis going to be. Telling me migraines means nothing. Telling me diabetes or skin cancer, none of that means anything to me. And honestly, I really don't care as an HR person. Right, that lacks complete empathy, but I really don't care. Like from an analysis perspective, I don't care about the actual condition itself. I just care about the impact that it's going to have. And if the person's saying that it's going to take time off, that they're going to need to take time off of work as a result of it, or they're going to need some sort of accommodation because they are going to have a prosthetic on their leg, then that's important for me. And then I can talk about, okay, then we get to the next phase, which is let's talk about some accommodations. But I need to get the medicals to understand, how long term this might be, what are the impacts, what's the effect going to be of this condition that you have, whatever it might be. So to understand disability, and I will caveat on this, none of us should be playing doctors unless you're actually a doctor, in which case that's great. But disability is a necessary element for any employee who is going to say that they need an accommodation, at least under disability laws. And so the thing is, so here's the definition of disability. So it's got to be a physical or mental impairment, substantially limits one or more of life's major activities. There's a lot there. That's the type of stuff that lawyers get into. It can be current or impairment or record of impairment. The thing is, when as HR professionals, when looking at this, if the employee comes to you and they say anything that sounds complicated, they say that they've got, some sort of condition, diabetes, skin cancer, whatever it is, and it sounds like, oh, that sounds like a medical condition. It's best, even if they say headaches, I wouldn't try to play doctor on this. What you don't want to do as an HR person is say, you know what? That just doesn't sound like substantially limits one or more of those life major activities. And then you start to pry, like, tell me exactly like how these headaches are impacting you. Do you feel nauseous? Is it impacting your ability to brush your teeth or shower or bathe or feed yourself? And you start going down the elements like we do, in legal briefs. That's not how HR people need to handle this, right? None of us need to be plain doctor. Leave that to doctors. Leave that to experts. And what I've said in the past on webinars, and I've told people is just imagine, because you're going to hear silly situations. You've probably already heard them throughout your career. Silly situations from employees who who need like mental health days or whatever it is like that, and they'll say that they've got some sort of condition that you've never heard of, and you think they're full of crap. And just imagine, like, say this worst case scenario goes to trial and there's a whole trial, and then it's like you, the HR person, on the witness stand talking about how you don't think that this employee has a disability. And then the employee presents for their prosecution. They present a doctor who says, no, absolutely, here are the ways that this headache is impacting the person, and they start listing. And who's a jury going to believe? I mean, all HR people are fantastic. Love them. That's me too. So, we are phenomenal people. We are not medical experts. and we really should not be opining on what it is and is not a disability. Best to just proceed with a strategy, a strategic response, and play it out. So in many ways, I kind of glance over when from a counseling, when trying to figure out like on the ground, like how to handle a disability accommodation situation. I just tend not to want to pry too deeply into the exact nature of the disability, but instead try to figure out a strategy and get them on the accommodation side of things. Now, as an employer, you do have to have knowledge, but the person doesn't have to just come out and say, I have diabetes, right? I think I started talking about that and probably got sidetracked. So they don't have to exactly have knowledge. You should be able to infer from the circumstances, however, reasonably infer from the circumstances that the person needs an accommodation. So if they never tell you anything, and let's just, say they have a little skin cancer and they just get it taken care of, and they never say anything about it, well, then you don't have knowledge. You need to know. But if the person says, hey, I've got to go see a doctor, I'll be gone for a couple days, and and by the way, when I come back, I probably will only be able to work half time. Okay, that's knowledge. That's at least knowledge enough to trigger some sort of affirmative duty that you should have to explore the situation and to get medicals and to look further into it. But the person doesn't need to say like, I have to have this accommodation. I am invoking my rights under the ADA to be accommodated here. They don't have to say that. You should just look at the circumstances. And if from the circumstances you can derive enough to know that there's some sort of medical thing going on here that could be mental or physical, that might need accommodating given what the employee's asking for. Now, if the employee's not asking for an accommodation, you don't have to start guessing and offering it up. But if they are indicating that they have some sort of medical thing and they're talking about whatever, the time off work or needing a segue or whatever it is, okay, that's enough for you to need to engage in the interactive process to start talking about, okay, get me some medicals. Let's frame this out. Let's try to figure out what this looks like. The person has to be qualified. This is where we often get employees. And applicants too. If after reasonably accommodating them, and again, reasonable accommodations are going to be different for every company, different for every situation. There's no just absolutes here. They need to be qualified. If they're not a qualified individual with a disability, then you don't have to then you can let's just get rid of them. You can fire them. They have to be able to do the essential functions of the job with or without a reasonable accommodation. That makes them qualified. So if after, let's just say we've got our diabetes guy buzzing around on the Segway scooter, we cannot. And we've got the good job description, and the job description says 50 pounds or more, and that's legitimate. Like he often needs to lift 50 pounds or more, but the prosthetic doesn't allow him to. And if we get through the conversation and we find out that, hey, there's no way for us to accommodate you reasonably so that you can lift these 50 pounds, because 50 pounds is in the job description, it's legitimate, it is essential to this job. But if the person we've tried to accommodate and we can't, but then they could do 9/10 of the job with the Segway and all that, but they can't do the lifting, but the lifting is essential, then they're not qualified. And that's at that point where the person stops being protected by the ADA. So we do everything we can to accommodate reasonable accommodations. That's all we're required to do. But if even after that, even after we've tried all the accommodations, the reasonable accommodations, if they are still unable to do the essential functions of any essential function of the job, then they're not qualified. And then they're not qualified for the job, and you don't have to continue to employ them in that job. But again, getting to that qualified part, we have to understand what the essential functions of the job are. And the exhibit number one for that is the job description, which is why job descriptions are so very important in this whole process. So there is an innumerable amount of types of accommodations that we can explore. So what exactly are typical accommodations? So it could be a modification of assignment or job duties, make adjustments. Here's what's easier to, right? So make adjustments to the job, make adjustments to the job application process, modify or adjust somehow the work environment, maybe even provide somebody with some sort of extra tool. But what you wouldn't have to do is, again, going back to my diabetes example, you would not be required under the law, even if you were Amazon with, billions and billions of dollars in the bank, you would not be required to purchase a prosthetic for that employee, right? So you don't have, if somebody needs glasses, you as an employer do not have to provide glasses for them. You don't have to provide prosthetics. You might have to provide a Segway scooter to get around. You might have to provide a better chair. You might have to provide a different desk arrangement, maybe a different keyboard, maybe different software programming, if these are all reasonable things, so that the person can do the essential functions of the job. But you don't have to provide the person with a wheelchair. You don't have to provide the person with glasses. You don't have to take care of their cancer surgery. You don't have to buy the prosthetic for them. You don't have to, in the diabetes situation, if the employee says, hey, what about one of my coworkers just does that part of the job, the lifting part that I can't do because it's 50 pounds or more, and I just will not physically be able to do it, and my doctor won't let me do it. How about we just have another employee just reassign that? You do not have to do that. That's why, again, we have to understand what's essential in this job. If it's essential, it doesn't have to be moved. The ADA does not require that you water down expectations of performance, and it doesn't require that you change the essential functions. It doesn't require that you hire somebody else or use other employees in the area to cover for the employee who's got the disability. So this is really important for us, right? If the employee just says, I do a lot of the lifting, but that's only like 10% of my job, and coworker on the floor can come and do that and pick up the extra. Absolutely not. You do not have to accommodate in that way. For that employee, you can accommodate all the other reasonable stuff, but what you need to do is accommodate so the person can perform the essential functions of the job. And if they still can't, then they're not qualified. But make adjustments to the work environment, make adjustments to the job, make adjustments, desk arrangements, software program, that sort of thing. That's all fine, but and required to do, but you don't have to hire somebody. You don't have to shift job responsibilities. And really, really important, you do not have to lower performance expectations. So if the person with the prosthetic, my diabetes example, let's just say it's a 10-pound essential function, and the employee is able to do the 10 pounds with the prosthetic. If the employee is only doing half as many boxes because they're just limited because of the prosthetic, if they're only doing half as much as their coworkers, you don't have to accommodate them by giving them the benefit of the doubt that because they're disabled, you give them a better performance review or not fire them. You can absolutely continue to discipline them. But again, this is where we want to be uniform. We don't want to seem like we're discriminating. So we want to have really good management practices throughout. Potential accommodations, we have to exhaust all potential accommodations. Go back to the drawing board. If you've tried an accommodation with the person and it doesn't work out, go back and try another one. Employers get to choose what the accommodations are, not employees. The employer's responsibility is to provide a reasonable accommodation, not the accommodation that the employee prefers, just an accommodation. So it's really important for employers that if the accommodation provided didn't work out and the employee still can't do the job and they seemingly aren't qualified, but there are other potential accommodations out there, we need to go back and try those again. We need to fully exhaust all potential accommodations before we can get to the point by saying, you know what, throw our hands up, we've done everything we absolutely can. We can't do more. You're still not qualified. everything we've done, you're still not able to lift, the 50 boxes that is required of all your other coworkers. Employees are required, like with employees as well, they are required to try to, do the job. So they are part of this interactive process as well. Just more of the stuff that we've kind of already talked about. Don't have to provide, we don't have to provide the prosthetic to them or anything like that. Accommodations, this interactive process, it needs to be in good faith. And that works both ways. I was kind of getting that point before. The employee needs to engage as well in good faith. If they say, no, I'm not gonna try that. I don't want to get on one of those Segway scooters and scoot over to the neighboring warehouse. Like I'm just not going to do that. I want a speedy little wheelchair that's gonna get me there. Well, absolutely not. If the Segway potentially works, the employee is required to try it. They're required as well in good faith to try to work with you, just as you are required in good faith to try to work with them on trying to see if you can accommodate them in the workplace and get them to the point where they're qualified for their job with the accommodation. So moving on to the interactive process. Here's kind of just a guideline for how we play this out. And the interactive process is critical. This is what we as lawyers, we want to defend you on. If you are involved in a failure to accommodate case, we want to demonstrate and document and show that you have done every single one of these steps through the interactive process to show that you have tried to accommodate the person, that you have done it in good faith, and that maybe in the end you just couldn't and they continue to not be qualified, but you did everything you could. And so here's the process that we've been talking about that we want to, just outlining and going through. Right. First, employee comes to you, you get some sort of knowledge, whether, employee comes and says, I've got diabetes, I'm going to have surgery. Okay, great. Meet with the employee. You find out, okay, you're going to have surgery. What's surgery on? They're going to remove my foot. Okay. So get some FMLA. You're going to need some time off, right? Yeah, I'm going to need some time off. Okay. Then how is the foot likely to limit you? Well, I'm going to have a prosthetic. The doctor says that I'll be able to lift up to 10 pounds. Okay. Second, get medical information from the doctor. Great. Go have your surgery, get the medical information. Let's find out from the doctor what this limitation, the physical limitation in this situation is going to look like. It's going to look like the person can't lift 10 pounds or more and probably a number of other things and walk around as fast. Okay, great. We understand what the limitations are from the doctor. We examine them. We then look at the job description and the essential functions, and we try to determine, okay, where is the gap here? Given the physical limitation, where is the employee not going to be able to meet the essential functions? On the lifting, first one, lifting requirement of 50 or more pounds, that's a problem. Then you go back to the employee. Okay, I can see right here from the essential function that you have to lift 50 or more pounds, and that's essential for your job, right? Yes, it's essential. I'm always lifting big crates, 50 or more pounds. Okay, how do you suggest, put it back on the employee, how do you suggest, and have them talk to their doctor if they need to, that we accommodate you so that you can lift the 50 or more pounds? Well, the employee says, I can only lift up to 10 pounds, but I'm thinking I saw on the internet they had this really sweet $500,000 lifting device that was really cool, and it had helicopters, spinner blades, and everything, and that would be really awesome. Okay, no, that's not really reasonable. We have 100 employees, and that those would cost $500,000. We're not going to do that. Anything else? Well, I was thinking that you just assign the duty, because it's only about 10% of what I do, that you assign it to my coworker. Okay, no, we're not going to do that because we don't have to, and because this is your job. We just want to try to accommodate you so that you can do the 50 pounds. And you keep going back and forth with the employee. And sometimes you might even try things out. You might try them out for a week or two, and you implement those accommodations, and maybe they fail. And then if they do, then you repeat it. And you go back and you're like, okay, well, we had 3 accommodations. We tried one. It didn't work. You're still not able to lift the 50 pounds. Go back and try another. And this might take weeks. It might even take months. Maybe, probably it won't, but it might. And I know it's a frustrating process, but it's a strategy and it's the process you need to go through. And this is how we do it. And eventually, if the employee they just cannot do the 50 pounds, then they're not qualified for the job. And at that point, then you go, last thing you do with the employees, just say, look, you're welcome to apply for any other openings that you're qualified for with or without a reasonable accommodation. Here are the jobs that we have available. You're welcome to apply for any. One thing you need to know about that's always your last thing, which is you're essentially firing them. But you're telling them what type of available jobs you might have that they could apply for. You do not need to give them a preferential treatment for those openings. If you have some sort of seniority that they could trigger, that's fine. Apply that. But just because you're transferring somebody out or firing them from a current job because of a disability, they don't get preferential treatment in getting that next job from you. You treat them just like anybody else under your typical policies. After accommodations, you can take a look at this, but this is pretty much what we just talked about, just making sure. And again, the thing that I really want to pound here is that after you've accommodated the person, and let's just say the accommodations work and the person seems to be able to do the lifting requirement and getting around on the Segway scooter, that sort of thing. How are they performing? If they're, you don't need to sugarcoat it for them. They don't get preferential treatment. You can continue to grade their performance, whether disabled or not, just as you would everybody else. And if they're just not keeping up because of the disability or otherwise, then that's fine. You can grade them on it, hit them on performance, but you are well within your legal right. It's not retaliatory as long as you're measuring them objectively, just like you are with every other employee. Now, of course, that assumes that your managers are doing a good job on reviews and all that, and that's a whole nother webinar. But anyway, the point is they don't get preferential treatment just because of their disability. We have 3 minutes, so we're going to go through as many of these examples as I can get through. I only have 2 or 3. Okay, so IT help desk, here's an example. During an interview, the applicant discloses that she may need an accommodation as she has diabetes. The position requires an employee to have an adjusted work schedule, overtime and weekends, in order to meet the deadlines to perform testing requirements. What accommodations might you give her to check her blood pressure or take insulin, which is what she's asking for because of the diabetes? So in this situation, applicant comes to you and you can have this conversation, and really at the applicant stage, you want to just make sure with them that, hey, are you qualified to do these duties? Here are the duties. Here's the job description with or without a reasonable accommodation. And they come in and they say, hey, I've got diabetes and I'm going to need to take some insulin and check blood pressure. Okay, get a medical framework for understanding it. Like, what does this mean? How long are we talking about testing? What does that mean to check blood pressure and take insulin? Is this an hourly thing? Is it a daily thing? Is it a weekly thing? What is it? So you get a framework understanding of what the limitations are, what is needed. Then you can look at the job description and see what the job requires. And then at that point, you'll then say, okay, you'll make the call, okay, based on what you need, how can we accommodate you? We require weekends, we require overtime. Is that going to impact anything? Here are the essential functions. And if you can have this conversation with the person and the person says, well, I can, that'll work fine. I can do this, that, and the other. I can test during breaks. I can take insulin. It's not going to impact my performance. I don't think it's going to be a big deal. Then you're fine. Then it's not going to impact the job. If it does impact the job, have the person come back and let you know, and you can try to reasonably accommodate them if necessary. But if it's not going to impact the job, then you're going to be fine. If the accommodation works and the person's able to perform the job, then you're totally fine there as well. So this is the process that you engage in, though. Okay, you know what? We're out of time. So we'll just pop to the end. The other 2 examples were really fantastic, but that's okay. We're out of time. Thank you for your attention. I think I think it worked out with the technical things. Hopefully everybody's actually here on the webinar and heard it. So I thank you for your patience on our first month with this. But we'll be back next month with the FMLA overview primer, and then we're going to do an advanced FMLA in April. So if you have any questions on the myHRgenius program or want to talk about anything with this webinar, feel free to reach out to me or any of the other attorneys at Thompson Co. I appreciate your attention and have a nice month.